Hello and welcome to this episode of the Smart Divorce podcast. And today we're going to be talking everything wills and powers of attorney. So strap in for a good one today. And joining me is the fabulous Michelle Tonge from Private Client Solicitors. Thank you for joining me today, Michelle.
Oh, you're welcome. Pleasure to be here.
So I think it would be best to start if you can introduce yourself a little bit, kind of how you've got to where you are, the heady heights, and then we'll get cracking with talking about wills.
Yeah, perfect. So I'm Michelle Tonge. I'm an Associate Solicitor at Private Client Solicitors in Manchester. So I'm a solicitor that specialises, as Tamsin said, in wills, powers of attorney documents, a little bit of tax planning for clients. But what we focus on is how to preserve wealth for the next generation. So how to pass on to children, family members, and just make sure that everything's runs smoothly once you pass away, because it often doesn't, unfortunately, because people don't get the right advice. And so I've qualified in 2020, but I've been studying private client law for the past 7 years. Worked for the current practice for 2.5 years, and we're now a team of 34 in Manchester.
Gordon Bennett. We should say at this point that Private Client Solicitors as a firm isn't actually that old, is it?
No, so the actual members of the firm, we've worked together for a lot of those for the past 10 years. I've been working with them for 7, but we used to work for quite a big practice, but we saw a little bit of a gap in the market where we wanted to provide that more boutique service to clients and just provide that really quite down to earth and honest advice for a decent price is what we're all about, really.
Absolutely, and a cracking job you do of it as well. So let's start off with talking a bit about wills. So I guess the starting point is, what is it and why should I have one?
So a will is a document that specifies what you want to happen to your assets if you were to pass away, or when you are to pass away. So it's really important to have in place, because if you don't have one, your assets could pass to people that you don't necessarily want. We could have probably quite a long conversation about why it's important to have one in place, but it is essentially a document that summarises exactly where you want things to pass.
Brilliant. And if I don't have one, what happens to my money?
So if you don't have if you don't have a will in place, something called the intestacy rules apply, which is basically a piece of law which says what happens to your assets if you were to pass away. And there's a specific order of who inherits in accordance with those rules. So they're on the government website, and they actually have like a calculator where you put in what family members you have, and it shows you how your estate would pass if in accordance with those rules. But those rules are often not what people want. One of the things that a lot of our clients don't know is that just because you're husband and wife and you're married or you're civil partnered doesn't necessarily mean your entire estate would pass to each other under the intestacy rules. So it's only, I think it's just above 322,000 that actually passes to the spouse, and then the rest would pass to between children and your spouse again. But that can lead, I've dealt with estates where that's led to minor children inheriting, but then the surviving spouse has had to sell their property because they've not got the money to pay their own children the inheritance. So it's really, it's just making sure that you're doing everything you can, even if that is what the intestacy rules say, to have it in writing.
Yeah, absolutely. So I can go to the post office and get a pack to draw up my own will.
We love a homemade will pack. Post office do them, WH Smith do them. You can, in theory, do your own will, and we would never say that isn't something you can do, but we highly recommend against it. There's so many reasons for that. I could probably talk all day about it, but
give us some of the big ones.
some of the big ones are you're not getting the right tax advice. So you might draft your own will, but not be aware of the tax implications of what you're putting in it. You might draft it one way, but that's actually read another way, and you're not covering all instances. We've had some homemade wills that we've dealt with afterwards for the probate where they've been that unclear in actually what they wanted to happen, that will has been considered invalid by the courts. And I appreciate that will's not necessarily cheap to do with a solicitor, but it is a very, 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 very small proportion of your overall all wealth. And that's the document that directs where it goes. So it's so important to get it done correctly. So solicitors are regulated. We're backed by somebody called the Solicitors Regulation Authority. So it's our responsibility to make sure that's done right. And we would, but even if we didn't, you've got another recourse. Whereas if you're doing your will yourself and you draft it incorrectly, there's nobody to turn to. That's on you. That's your fault. And there are other people out there who draft wills, such as will writers who aren't solicitors. Some of them are probably really good, but again, they're not regulated and they're not backed by insurance. So you've just got to make sure that you're getting the right advice from a specialist.
Yeah, absolutely. And in terms of things that you need to think about before you go and see a solicitor to get your will drafted, what do I need to have with me? What things should I be thinking about before I go and see a solicitor?
I think that the first step is to actually have a conversation. So say you're a couple, having a conversation between yourselves about what you think you want to happen. Because I quite often have meeting with clients and they've not actually had that clear conversation about where they want their estate to pass. So I can certainly give you the right advice about how it should be legally structured, but I can't tell you who to give your money to because that's a decision for you. So the first thing is really to have a think about, who do I actually want to inherit this money? And are we both in agreement with it? And then also just to have an overview of what you actually own. So a lot of people accumulate wealth over the lifetime. They might have different pension pots. They might have different bank accounts. They might have different shares, but they don't actually know what they own. But it's useful when you have a meeting with a solicitor to do your will or with somebody to do your will, if you can give them an overview of what assets you actually have. Because you might want to give a specific asset to a certain person, but even if you don't, and we're just dealing with the estate as a whole, we need to have an idea of the value of it so that we can give you the correct advice.
Sure. And once I've come to see you and we've talked about where I might want, let's say, situation's fairly straightforward. We've got husband and wife, there's 2 children, they want the children to inherit, well, they want each other to inherit, if not each other, then the children. Are there other things that we need to think about?
Yeah, so there are other things that you need to think about as well. So what one is the tax aspect of it. So you need to have a think about whether there's going to be any inheritance tax payable on your death, because that might change your opinion on how the will's structured. You might want to include other things in the will, such as funeral wishes, for example. So you might want to specify whether you're to be buried or whether you're to be cremated or whether you want a religious ceremony. There's things like default beneficiaries to consider as well. So Armageddon scenario, everybody passes away, who's to inherit our estate? Because if you don't specify, it goes back to the intestacy rules, which we talked about previously. Also, a big one that people don't have the conversation about before is, yes, you are giving to your children, but at what age are your children to inherit? Do you want to give an 18-year-old a big chunk of money? Probably not. I mean, some 18-year-olds might be different to others, but I know if I had that money at 18, I would have probably blown it at university. So it's things like that to consider as well. And also, if there's anybody vulnerable in the family, you might want to think about protecting their money via what's called a trust. So if anybody's entitled to benefits, for example, or if somebody's quite frivolous with money, or if one of your children have a spouse or partner that you don't necessarily like, you might want to ring fence that money and protect it from kind of threats to the estate. And it's really just having a look at, yes, this is what we want overall, but is this definitely the best structure? And does this provide the family with the most protection going forward?
Okay. And what about the executors of the will? How would you suggest going about choosing them? So if we've got husband and wife and we've got 2 kids and they're both under 18.
So executors are really, really important. So just to explain what an executor is, it's the
Perfect.
person who's responsible for administering an estate. So they'll deal with all the paperwork. They'll apply for something called probate if they need to do that. They'll deal with settling any inheritance tax. If it's the situation you just described, where it's a simple will between husband and wife, and then everything passing to the two children at 18, it might be on the first person to pass away, so the first of husband and wife, that they're happy to just appoint each other, provided that they're happy with that, they trust each other implicitly, they've got no concerns about them being emotional and being able to deal with it at that time. But then you really need to consider, who are we appointing on the second death? Who's looking after this money on behalf of our children until they reach the age of 18, if they're not already? You can't appoint the children if they're under 18. And even if they are above 18, say they're 18, 19, you still might not want to put that responsibility on the children. And you might want to include an age of 25 in the will, for example. And so it's just thinking about, who do we trust to look after that money for the children, whether that's a professional, whether that's a family member, whether that's a friend. And are those people going to get on as well? Because something we unfortunately see in practice quite often is that people appoint to executors who actually don't like each other, whether that's two children who don't like each other, or two friends who don't like each other. And it can cause problems further down the line, because it's such a big responsibility to be an executor. You've really got to think about it and be happy that that person's going to act in the best interests of the beneficiaries, the children.
Wow. Okay. So that's another thing that perhaps needs thinking about before they come and see a solicitor. Okay. So let's say we've put the will into place. So I've done it. Everything's hunky-dory until I die. Is that the case? Are there anything that means that will's not valid any longer?
There's quite a few things. So we always recommend that you review your circumstances every 3 to 5 years. So we offer a free will review service for clients. The reason being is your circumstances might change in those 3 to 5 years, or you might have a life-changing event anyway, such as maybe have more children, maybe have more grandchildren, maybe you get divorced, maybe you get married. But all of these things can impact how your will is structured. And particularly if you get married, that actually revokes a will. So the law says that if you get married, it's as if you'd not put that previous will in place, unless you put the specific clause in it to start with. So you should certainly every few years, or if a life-changing event happens, get that advice, just to make sure it still is up to date. And also the tax legislation can change. So depending on who's in power, it might change from one 5-year period to another 5-year period. So we're reviewing a lot of wills at the minute that were done before 2017, which now need to be updated because the inheritance tax legislation changed them. So it's definitely worth reviewing it. So please don't just do it and think, I've done my will, I never need to do it now until I die.
That's me.
Yeah. It might be, and it might be that it is still okay. And if it is, we would tell you that. And most of the time, we do review a will and say, actually, this is completely suitable for your circumstances. But what might be your concerns when you're in your 20s probably isn't your concern when you're in your 60s or 70s. So you might start thinking about things like care fees, inheritance tax. Even younger than that, you might start thinking about those things. So yeah, review your will.
Good advice. So marriage revokes the will, but divorce, that doesn't automatically revoke it?
Yeah, you're right. Yeah. So with marriage, that does revoke a will, because I presume the reasoning for that is that you've now married a person, you say you want to spend the rest of your life with them. So any will that you'd made giving things to somebody else now isn't valid. With divorce, it doesn't necessarily revoke your will. So your will is still in place, it's still a legally valid document. However, it's treated as though that person, so your ex, had provided you are divorced, had passed away before you. So if you had a will leaving £500,000 to your spouse or a civil partner, if you then got divorced, that gift just wouldn't happen. But that divorce would have to be final in order for that to be treated that way.
That's interesting. Crikey. Okay, so if you're getting married, or if you've got married, redo your will. If you've got divorced, definitely redo your will.
Definitely.
Okay.
Yeah. And we get a lot of clients who've started the divorce process but haven't finalized it yet. So they might have something called the decree nisi, but they've not got the decree absolute, which is basically the final bit of the divorce. And until you've got that, if your will is still valid, and even if you don't have a will, the intestacy rules apply again, and the spouse is the first person to get it, even if you're separated.
Yeah, and to be honest, there are situations where that actually does, where it makes sense for the spouse to get it during the divorce process. So we're working with somebody who that did happen to. They were in the process of getting divorced. They got the conditional order. They were waiting for the final order, and during that time, sadly, her husband passed away. And we know it's a long and complicated story, which I won't go into, but we knew that the husband wanted their son to inherit the estate, but actually it made a lot of sense for her to inherit it for tax planning reasons. And, you know, in those circumstances, actually, whilst you're going through the divorce and it's not finalized, it does actually make sense to kind of leave your will in place, especially if there are children involved.
Yeah, and the other point to consider is that if that did happen, because we've got 2 files at the minute where that's actually happened as well, the spouse could still have a claim on the estate if you cut that spouse out of the will. So you've always got to be very cautious of, yes, I'm cutting this person out. We're separated, don't like them, don't want them to have any of my funds, but then that could actually lead to quite long and upsetting and emotional legal proceedings further down the line. So you've got to be very careful and get the advice during that period to make sure you're considering absolutely everything.
Yeah, definitely. So there's another situation that I wanted to talk to you about, because this is something that happens a lot and that we come across a lot. And that's where this is a second marriage. So there are perhaps sort of separate families, children from previous relationships on often both husband and wife side. And you might say, well, I want my spouse to inherit initially, but actually I don't then want them to be able to write my children out of any inheritance later on. Are there things that you can do to protect that situation?
Absolutely, yeah. And it's a really, really common situation now, particularly the modern day family. That tends to be a lot of people's situation. So what the issue with a simple will structure, so the one we talked about at the beginning, where it's everything between new partner, husband and wife, spouses, and then everything to children, is that if you're saying, I give everything to my spouse, that spouse is then free to change their will. They could decide to cut your children out completely. They might get remarried again. So what we tend to recommend for that situation is that instead of doing a simple will, leaving everything to each other outright on the first death, you incorporate something called a life interest trust. And what that does, in essence, is it means that your new partner can benefit during their lifetime. So they might have a right to live in the property because you wouldn't want them to be homeless. They might have a right to any income. If they needed some money from the trust, the trustees could give it them. But the underlying capital is preserved for the respective children. So it might be that you have the same will structure in place, but the beneficiaries of yours are your children, and the beneficiaries of your partners are their children. And it just ensures that you're still making sure each other are okay, and you're making sure you can each benefit from your own wealth during your lifetime, but you can't go and spend it, you can't go and give it away, and you certainly can't cut the kids out in the future, because sadly people do move on and families do fall apart. So it's making sure that you're protecting it.
Okay, tell me a bit more about trust, because we've mentioned trusts a few times. So just very straightforward and simply, what is a trust? What does it do? How are they set up?
So trust, I will not bore you with the details of trust because that's a 3-hour conversation on its own. I always give the example to a client. It's as if you're locking something in a safety box. and you deciding who has the code to it to look after it. So a trust, it's got three parts to it. So you've got your trustees, who are the people who control the trust. And as the name suggests, it should be people you trust implicitly. Then you've got your trust assets. So that might be, in your will, it would be everything that you own at the date of death. And then you've got your beneficiaries, so who you want to benefit from that trust. So they might be partner, they might be spouse, they might be children, they might be friends, they might be charities. So it's essentially a way of planning to protect, to give you more control, or give the people you choose more control over that inheritance.
Okay. So it's not directly going into somebody's bank account that might not be of an age or a mindset to work out for themselves how to control it.
No, definitely not. And so the trustees of who you appoint to control it, although they can decide who benefits and when, what they can't do is spend that money on themselves necessarily, or it's meant to be for the benefit of the beneficiaries. So but they are amazing estate planning tools, trust, because they give you so much flexibility and so much tax planning opportunities that they're definitely worth having a conversation about.
Absolutely. And when you go and see a solicitor about your will, they will undoubtedly talk to you about trusts and about whether they're appropriate for your circumstances.
Yeah, definitely. And there's different types depending on what you want to do. So they might be for your will, they might be during your lifetime. And it all depends on what that person wants to achieve and what their concerns are. And to be honest, that's how we tend to start the meeting, like what actually are you worried about happening?
Yeah. Well, that's good advice. And the other thing that is kind of, I suppose, future-proofing or putting things in place so that whatever happens to you, you've kind of given the control that you want to the people you want to have it, is lasting powers of attorney. So very basically, what is a lasting power of attorney and what does it do?
So just to start with, they are completely different to a will, a completely separate document. And sometimes people get them a little bit confused. A lasting powers of attorney is only valid while you're alive, and they're used if you've lost mental capacity. So if you, for some reason, can't make decisions for yourself, that's when this document comes into place that you can use. So there's two types of documents. One is for your property and finances, and one is for your health and welfare. So your property and finances, for example, if you couldn't make decisions about your own investments, about your own pension, you can appoint people you choose, your attorneys, to make those decisions on your behalf. And that one can be used if you've still got capacity and you can still make decisions for yourself. But for example, you don't feel well enough to go to the bank. So it might be that you say, oh, please, can you go to the bank for me, attorney, because I want some cash out. So they could use that document to make decisions for you, but only, again, they can only be used for your benefit. The other document is for health and welfare. So that's a equally as important document, and I think sometimes people don't think it is, and they tend to just put the finances in place, because to me nothing's more important than my health. I would quite happily be poor and still have my health. But it's that document can only be used if you've lost capacity, and essentially it's in relation to things like life-sustaining treatment. So if I was in hospital, I had a very small chance of coming back to consciousness, would I want the doctors to make that decision on my behalf, or would my family and friends know what I wanted to happen, and who would I rather make that decision? But they're not just in relation to life-sustaining treatment. They're also quite really important if you ever ended up in care, because if you can't make decisions for yourself, you need somebody to be able to make those for you. So I don't know if you saw on the news I think it was during COVID, that this lady had a mum in a care home who was in her 90s, and her sorry, just take a quick drink. Her mum was in her 90s and she was in a care. Oh, sorry, Tamsin, I've got cough. Oh. So we I don't know if you saw on the news I think it was about 2 years ago, there was a lady who had a mum in a care home who was in her 90s, and she wasn't happy with the care that her mum was receiving in this care home. She had power of attorney just for finances, And she went to the care home and said, I'm taking my mum out. She's not happy here. I know this isn't what she wanted. She actually ended up getting arrested, and this lady was in her 70s herself because she had no legal authority to take her mum out of a care home. And it's really sad because you know when you hear that story that she had her mum's best interests at heart. But as far as the local authority was concerned, they didn't know this person. They didn't know that she had a relationship with her mum. And they said, no, we can't, we think it's in her best interest to stay. And she had to go through the courts, and that's a very long and time-consuming and emotional process.
Wow. Crikey, I've never heard that before. That's horrendous. I mean, I would always suggest getting both done because you, as you said, you want somebody to be able to make the decisions. Things like whether you want somebody to be resuscitated. I know my grandpa had a do not resuscitate on his file, which was ignored, unfortunately, on a number of occasions. But things like that, you know, would you want, do you know if they would want their life support turning off? Those sorts of things are massively important. And you know that if you've had those conversations with your family, that they know what you would want and they will operate in your best interest. So no, for me, I'm with you. Health is definitely as important as the finances one. So yeah, well, in terms of the finances one, so I have some questions, as you can imagine.
Yeah, I'm sure you come across it.
Absolutely. So you have your power of attorney, you fill the form in, you write it all up, and then it needs to be sent off to somewhere, and you pay some money, and from memory, it's just under 100 quid.
Mm-hmm.
And that registers it. Does that mean with the finances one, from that point of registration, it can be used if needs be?
Yeah, it can. So you don't have to register your lasting power of attorney documents. You could just sign them, and then they could be registered by your attorneys if you then lost capacity. But we don't recommend doing that. One, they're taking about 6 months to come back from where you send them to be registered at the government body called the Office of the Public Guardian. And also, it's if you need them for some reason, you probably don't want to have to wait that 6 months. And another reason is that if they then come back, because they're quite particular in how they signed, and the Office of the Public Guardian aren't happy with them, you can't then put one in place if you've lost capacity to be re-registered. So we always recommend registering them. And yes, you're correct in that they can be used from that date. So like we said before, if somebody wanted to go to the bank on your behalf, they could do if that document was in place. But you should never appoint somebody who you should always be happy that that person's going to act in your best interests. Sure. And 9 times out of 10, those documents just sit there until they are actually needed. Sometimes mostly in a solicitor's office. And then if they are needed, they're then ready to go from day one.
Brilliant. There was a case, and I think it was something from the news. I don't think it's somebody that I've worked with personally, but that was in a foreign country, and there was some kind of emergency requirement for money, not one of these scam things, because I know you see loads of those happening, but a genuine, they needed some money moving about in the UK, transferring from one account to another for themselves, not sending it to like some random person in Sudan or whatever, but actually for use themselves. And they needed somebody to move some money about, and they used their power of attorney to enable them to do that. So as you said before, it can be useful. It's not just about doing it when you retire. It's about putting them in place early on, because you never know when you might need it.
Completely agree. So yeah, it's just to confuse you, there's another type of power of attorney that can only be used if you have got capacity called a general power. So they're often used, and the reason I bring them up is they're often used if you just need the same week, you don't want to wait for them to be registered, you're in a different country and you need somebody to access money on your behalf, you could literally just do a document with a solicitor that says, I give this person authority to make this decision, but they are only valid while you've got capacity, while lasting power of attorney documents are when I've got capacity and also when I've lost it. So they're the best ones to put in place. They just take a few months to do and to register.
Fair enough. And so if I let's say I'm going traveling for a year and I just want to make sure that should I need somebody to do anything financially in the UK while I'm away, that they can, and there's going to be no tripping up. What do I need to provide them with? Is there a copy of the registered power of attorney that comes back from the Office of the Public Guardian then?
Yeah, there is. Yeah. So I would always make sure that people have either the original or the solicitor certified copies. So the places like banks, etc., will only accept certified copies of the documents. It's also become a little bit more modern now with the finance document in particular, where the banks will have like an online registration of who the attorneys are, and they can find who's attorney for that person. But yeah, always make sure you've got identification whenever you're going anywhere, and always make sure you've got a copy of the power of attorney just in case.
Brilliant. Okay. And another thing that I just wanted to touch on with you, largely because it came up in a client meeting this morning, and I was like, oh, that's interesting and something that I should talk to Michelle about. So this is about ownership, particularly of your main home, so your main residence. So this particular client, without going into too many personal details, had asked me about the different types of ownership for a property and why they might want to do something different from what's in place at the moment. So to begin with, what are the different ways that you can own a property?
So if you own property jointly, which a lot of people do, there's two different ways that are very separate as to how to own property. So one is called joint tenants and one is called tenants in common. Difference is that if you own your property as joint tenants, then that property, if one of you passes away, automatically passes to the surviving owner. So it's as if you own that property as a whole, and you can't direct in your will where your share of that property goes. You own it jointly with that person, and it will pass to the survivor on death by way of law. Doesn't matter what your will says. With the other option, so with tenants in common, you each own a distinct share of that property. So it might be that there's two owners and you each own it 50%, 50%, or it might be that the percentages are different. With tenants in common, you can then specify who is to inherit that on your passing. So the situation we covered before about families where they've got children from previous relationships, they usually want to own their property as tenants in common because they want their property to ultimately, at the end of the day, pass to their own respective children. Still have the right to live in it, but they wouldn't want the property to just automatically pass to the survivor. Sadly, we see a lot of cases, maybe where people have done their own wills or they've not got the right advice, where they've not changed their ownership when they've been doing this structure, and the property just negligently passes to somebody they didn't want it to pass to. And that's also the case if you get divorced as well. So even if you get divorced, if you don't change that property ownership, then it's not passing to who you want it to.
Absolutely. No, that's massively important, isn't it? To kind of think about that. And I think you're right. I think people kind of think, oh, that's a good idea. I'll structure things like that, and actually don't change they'll set the will up and put everything in there, but don't necessarily do the final bit, which is actually the doing of making sure that it's owned right.
Even though the property is sometimes the biggest asset, but it's you will get asked when you buy a property, how would you want to own it? Do you want to own it as joint tenants or tenants in common? But for most people, it's either not explained correctly, and it's not talked about in conjunction with death. It's not, nobody talks about, you're not buying a house and your conveyancer goes, but what if you die? So
what do you want to happen then?
Yeah, I know this is a really happy time in your life, you're buying your first house, what if one of you passes away? So it's thinking about these extra things, and when you do your will, it's a natural time to do it. And we always look at how, and if all properties owned, not just your main residence, it might be a common one that I've had a few times is people have inherited property from parents, kept owning them with siblings, not realize that they own them as joint tenants, and then they pass away, and the sibling gets the whole amount because that's not what they wanted to happen. So it's so important to check the ownership, and we can do it. I think it costs us £3 to download a copy of the title from the land registry.
Most people can probably just about cope with that. That sounds pretty good advice. I think there are some really good examples of where property's been owned as tenants in common, and it is absolutely the right thing to do, but it is about making sure that it's right for you and your circumstances. So just an example, just to, I don't know, just kind of show how it can work. So my grandparents lived with my dad and my stepmom, and they owned a house. It's very complicated, but it was a house that was sort of split into two. So my dad and my stepmom lived in one half, like one side of the stairs, and my gran and granddad lived in the other side of the stairs. My granddad got sadly very poorly and he passed away, and they each owned 25%. When he passed away, I think the way that they did it was then they each, I think that they then split it so that they each ended up with a third. And then when my gran passed away, her third got split in two, and then my dad and my stepmom then ended up with half each, which absolutely makes complete sense. And for their structure and the way that worked, because obviously it was my grandma and granddad, and even though my stepmom wasn't related to them, she'd lived with them and she'd cared for them and she'd looked after them when they were older, so they wanted her to inherit their part of the house, even though she's not blood family, because they were like grateful to the way that she'd cared for them, and and looked after them and fed them and lived with them and so on. So but circumstances like that can be absolutely ideal for a tenants in common situation, but you've got to understand what you're doing and the pros and the cons, like what things can go wrong. So and I think if you talk to a solicitor, they will explain that to you.
Definitely. And on the other side of that, on the flip side, it might be suitable for you to own a tenants in common. If you just want no hassle after the first person to pass away and you just want your spouse to inherit the property, then that's absolutely fine. We might as well own it as joint tenants. So we have changed properties away from tenants in common back to joint tenants, but you just have to make sure it's 100% the right thing to do. Also for clients who want to make sure that all of their inheritance goes to the children and that they might be worried about going in a care home in the future, tenants in common is a very, very good way of owning your property, because you don't necessarily want the entire property to pass to the survivor of you if you're in your 90s and in poor health, because at that point it might end up going on care fees. So you have to make sure it's tenants in common and that you will structure correctly. So there's so many different things to consider. That's why it's useful to have the conversation.
Absolutely, and have the conversation with somebody who knows what they're doing. I know lots of people want to protect their property from being spent on care fees. Having said that, if you've spent your life making decisions and choosing nice places to live and wanting to give yourself choice, actually you might think, well, I earned this money, it's mine, and if it doesn't go to the children, it doesn't go to the children, but if it means that I can live somewhere nice that I choose to live, then you might be quite happy. And those are conversations that you need to have with your solicitor, aren't they?
I think that'd be my opinion on it. Because clients do say sometimes, oh, I really want to do some care fee planning, and I think it's quite a bit of cash there. You're sure? Do you not just want to go in a nice care home? So I completely agree with you. And the key is each person has different opinions on things and different views. And going back to what we said at the start, different concerns. And if you're adamant that that's what you want to do and you want to protect it, then we can probably help to do that. But at the same time, never starve yourself of cash and assets just because you want to protect your children.
Yeah, and you might not want to go in the local government care home when you can go in somewhere nice with a nice big lake and park outside for you to go and have a look at every day. That's me. Sorry, kids. We are just about coming to the end of our time together, Michelle. Is there anything that I should have asked you or anything that you want to add?
No, I think that's great. I mean, just from our perspective, it's if anybody has listened to this and thought, oh my gosh, I need to review my will, or I need some advice, I'm always happy to have a conversation. I know solicitors get a bad rep sometimes of giving you a big bill, but we're completely happy to do a free will review, kind of a free, no obligation chat. It's really important to us that everybody gets access to estate planning advice. So even if it's just a conversation and you don't actually need to do anything, happy to have it.
I appreciate that. And I know that you're in Manchester City Centre. Do you only work with people who can come and see you face to face, or are you able to work with people remotely as well?
100% able to work with people remotely. I think everybody's gone a little bit more in that direction since we're all working from home a little bit more. So we do have offices in Manchester City Centre. I would also go and see clients in and around the Manchester area at their house if that's where they prefer. But also sometimes it's easier to actually just hop on a Teams call or a Zoom call, or just have an old-fashioned phone call. But we work with a lot of clients remotely. We work with a lot of clients who have assets overseas or who are based abroad. Got clients in London, got clients in Liverpool. So yeah, basically anywhere across the UK or anywhere in the world, we can still help.
Wonderful. It's always worth covering that, because I know we do have listeners from all across the UK, and somehow we have listeners in Mongolia as well.
Amazing. Well, never done that before, but yeah. I'm not an expert in that law, but anything to do with the law of England and Wales.
Perfect. That's brilliant. Thank you so much for joining me today, Michelle. It was really useful conversation.
Oh, it's been a pleasure. I love to speak to you, Tamsin.